This is the recorded lecture for Chapter 6, Criminal Procedure. This chapter takes a closer look at procedural due process. It focuses on the 4th, 5th, and 6th Amendments to the U.S. Constitution and how they have been interpreted over the years. Technology, beliefs, and values have changed over the 240 years our nation has existed, and the law has had to keep pace with those changes. New rules and precedents are set as new circumstances present themselves. By the end of this chapter, I hope that each of you will be able to state the due process guarantees of the 4th, 5th, and 6th Amendments, as well as the precedents that elaborate upon them. Be able to apply Packer's models of the criminal justice system to the due process laws and show where and how those laws fit into those models. Explain how the due process guarantees and case law operate along a continuum or pendulum between the two models in an effort to balance community safety with the protection of individual rights. And be able to define and give examples of the following terms or concepts: probable cause, reasonable expectation of privacy, search incident to arrest, consent to search, plain view doctrine, open fields, abandoned property, seizure or detention, reasonable suspicion, Terry stops, knock and announce rule, exclusionary rule, Miranda warnings, custodial interrogation, exclusionary rule, the silver platter doctrine, and fruit of the poisonous tree. The purpose of criminal procedure law is to strike a balance between two competing, equally desirable goals: community safety and individual liberty. We all want to have our freedom, but we also want to be safe. Individuals cannot enjoy their freedom if they are too afraid of one another to engage in community. If you recall from our study of social contract theory, particularly that of John Locke, individuals consent to be governed so long as the government does not abuse its power. So we built a government of laws that protects our freedom while also providing order, predictability, and safety. There is a balance that must be maintained between rules that keep us safe and rules that keep us free. Criminal process is that great balancing act. It's easy to see that balance when we apply Herbert Packer's models of the criminal justice system. On the due process side, the chief concern is protection of individual rights, even at the expense of a factually guilty person avoiding punishment. But on the crime control side, the chief concern is community safety, and government is trusted and less restrained in the belief that most defendants are factually guilty and deserve to forfeit their liberty. Now, we know that our justice system doesn't fit entirely on one side or the other. In our justice system, we authorize the police to arrest suspects, to seize property, to search us, to come into our homes and search our homes and cars. We authorize the government to take away a person's freedom entirely for their entire lives. But the government cannot exercise all that power unrestrained. As a matter of constitutional law, individuals are presumed innocent. The government bears the burden of establishing legal guilt beyond a reasonable doubt. And there are hurdles or obstacles that government must surmount. Those hurdles or obstacles are the application of due process. So in practice, our government operates somewhere in between the two models, as I mentioned earlier, to balance the concern for community safety with the concern for individual freedom. But you must recognize that for every power that is given to the police to protect the community, you sacrifice an equivalent amount of freedom. And for every obstacle you place to preserve individual freedom, you sacrifice an equal measure of community safety. It is a zero-sum game. When in balance, the two sides counter each other equally, and the pendulum rests over the zero in the middle of the continuum. We've already identified where procedural due process rights are protected: the 4th, 5th, and 6th, and also really the 8th Amendment as well of the U.S. Constitution. We also learned that there are several individual civil freedoms guaranteed specifically in the Bill of Rights, and some impliedly through the exercise of substance. What you also need to recognize is that state constitutions may also guarantee protection of individual freedom. For example, with sentencing guidelines or rules of criminal procedure. States can add more rights, but they cannot subtract from the rights guaranteed by the federal Constitution. And don't forget that the U.S. Supreme Court has interpreted the Due Process Clause of the 14th Amendment to include or incorporate nearly all of the rights contained in the Bill of Rights. So states cannot make laws that would lessen the rights guaranteed in the U.S. Constitution. The Supreme Court has the power of judicial review, so ultimately, the interpretation of the due process amendments and the determination of whether rights have been violated happens in the courts on a case-by-case basis. The constitutional case law that emerges from the exercise of judicial review provides a second source of criminal procedure law. We're now going to go through each of the due process rights and study how the courts have interpreted them. As we do that, you'll start to see a pattern develop. There's usually a general rule provided either by the Constitution or by some case precedent, and then there'll be a number of exceptions or elaborations on that rule. Search and seizure law has its origin in the 4th Amendment. So we'll start our study by looking at that amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. This amendment has two clauses: a reasonableness clause towards the beginning, which provides that government can conduct a search and seize a person or property, but the search and seizure must be reasonable. And second, a warrant clause, sort of the second half of the amendment. Warrants must be based upon probable cause and describe the subject of the search or seizure with particularity. So what we're left with are really four general rules. First, officers must obtain a warrant before conducting a search of a person or his or her property or effects. Now, there are exceptions when a warrant isn't required, and we'll go over them in a moment. But the general rule is officers must have a warrant. Second, the warrant must be based upon probable cause. Probable cause is defined this way: the facts and circumstances within the officer's knowledge and of which they had reasonably trustworthy information are sufficient in themselves to warrant a man of reasonable caution in the belief that an offense has been committed. Now, that has got to be one of the most ambiguous definitions I have ever heard of. It is really a judgment call. And fortunately, we have more than one person who passes upon that judgment, and we come up with, most of the time, a pretty high consensus agreement on what is and what isn't probable cause. But it is going to be a subject of debate because that definition is so ambiguous. What is reasonable? I mean, if you look that up in the dictionary, reasonable is it has reason. I mean, it's just a very factual judgment call that you develop the judgment and understanding through practice. The amendment also reads that the warrant has to be supported by an oath or affirmation. And what they're talking about is that an officer or witness has to provide either a sworn statement or an affidavit, some type of testimony under oath that demonstrates the probable cause which supports the warrant. The third rule is that the search must be reasonable. So again, we have this really ambiguous word, reasonable. It has to be reasonable in scope, and really that just means it's got to be, the scope of the warrant has to be commensurate with the probable cause. In practice, that's how it kind of plays out. The fourth rule then is that the warrant must describe the subject of the search with particularity. So the specificity in a warrant is going to limit the discretion of the police officer who's carrying it out. So it's sort of a way to rein in the power of the officer when they conduct their searches or arrest somebody. So as mentioned earlier, in criminal procedure law, there is usually a general rule, and then there are exceptions to that rule. So as expected, there are exceptions to the Fourth Amendment's rules. The first is exigent circumstances. So a warrant for a search won't be required if there's probable cause and there are exigent circumstances, some sort of urgency in the situation that justifies an officer not stopping and getting on the phone and calling a judge and getting a sheet of paper signed, giving him a warrant to go and search or arrest. So there's some sort of urgency in a situation, but probable cause is still there. So that's the exigent circumstances when he doesn't have to stop and get a warrant, or she doesn't have to stop and get a warrant. Okay, a second exception to getting a warrant is for a search incident to an arrest. This is sort of a narrow search. So it's not anything goes search. It's very narrow. So at the same time as a valid arrest, we'll go over the rules for valid arrests in a minute, but if it is a valid arrest for any offense, a search can happen, but the officer's search is only for the lunge area or the area that's within the suspect's immediate control. And the purpose of the search is just to protect the safety of the officer, just to make sure the suspect can't like dive for a weapon that's right next to him to use against the officer, or flush drugs down a toilet real quick that's right there. So it's a valid arrest, not a temporary detention like a traffic stop, an arrest for any offense. The officer can conduct a search of the suspect and the lunge area or the area within the suspect's immediate control for the purpose of protecting the officer's safety and preventing the destruction of evidence. All right, the next exception is for vehicle searches. Police can search a vehicle without a warrant only if they have probable cause and the vehicle is mobile. Now, don't confuse this exception with search incident to an arrest. That's got its own little analysis. Once an arrestee is secured, the police may not use this vehicle search exception to continue searching all through the car, unless, of course, there's always an unless it's for evidence related to the arrest. This exception is just to account for how easy it is for a running vehicle to become a getaway vehicle. Okay, so there's a lessened expectation of privacy over a vehicle that's in the public anyway, versus when a car is parked in your garage. So you have this exception if the vehicle's mobile and could become a getaway car really quick, and the officer has probable cause, they can conduct a search of the vehicle. Okay, next is administrative searches. Examples of this are like locker searches at a high school, like the security officer who's in charge there can search a student's locker, for example, or government regulators can come and search a business to make sure that the business is complying with the regulations. Parole officers or probation officers, they can conduct searches without a warrant. The reason that the warrant's relaxed in these situations is because most of the time there's another agency involved, like a school, and there's a heightened public interest in the search. So we don't want kids bringing drugs and weapons to school. So we're going to search lockers every now and then. And then often we're talking about a very negligible intrusion in privacy. So that's the exception for an administrative search. The next exception is for consent. A person can simply agree to a search. And as long as their consent isn't coerced, it's fine. Police can request to search property without any basis for conducting one, and the police don't have to inform the suspect of their right to say no. And a person's consent can be limited to a specific area, or it could be withdrawn at any time. And valid consent can only come from a person with the apparent authority to give it. For example, consent can come from your roommate when you're not home, but it can't come from your roommate if you are there and you're saying, no, you can't search my apartment. So if you're not there, your roommate can say, yeah, police, go on and search the place. But if you are there and you're saying, heck no, police, you go get a warrant, your roommate can't overrule you and let the search go forward. I thought y'all might be interested in that one. Okay, so that's consent, administrative searches, vehicle searches, search incident to an arrest, and exigent circumstances. These are when warrants aren't required. Now, the textbook identifies some other situations and kind of labels them as exceptions when police can conduct a search without a warrant. But they aren't really exceptions. They're just situations where the Fourth Amendment doesn't even apply in the first place. So I'll show you what I mean. But first, we have to start by identifying when the Fourth Amendment does actually apply. So the case law interpreting the Fourth Amendment provides that its protection applies only to a search of property over which a person has a reasonable expectation of privacy. So that's an important concept for you to learn. Reasonable expectation of privacy. That has to exist before the Fourth Amendment will even apply and require a warrant. So what does that mean? Because we still have this really ridiculous word, reasonable. Okay, so we have a better definition in this situation than we did with probable cause. A reasonable expectation of privacy, it means objectively reasonable and subjectively reasonable. So it's both things. To have a reasonable expectation of privacy, there must be objective reason and subjective reason. Objective reason just means society. Any person would think that that property is private and can't be searched without a warrant. And the actual owner of the property actually believes that it's private and means for it to be private. So you have to have both of those things. And I like to give the example of a woman's purse. Okay, so the owner of the purse, the woman, of course, believes that the contents of her purse are private. So that's subjectively reasonable. But also, everybody in our society knows that the contents of a woman's purse are private. So it's objectively reasonable to expect a woman's purse to be private and therefore a warrant required for its search. If the expectation of privacy over the subject of the search is not both objectively and subjectively reasonable, then the Fourth Amendment protection simply does not apply. And examples of that are items that are in plain view. So what an officer can see when they are lawfully present on the premises, and that's just plainly right there, out in the open. Well, that's clearly not private. It's in the plain view of the officer. So the Fourth Amendment isn't going to apply. And this is a situation when it's something that's like obvious right there in front of the officer's face, not where the officer kind of can move things around, like pick things up and look underneath it or look under the bed. No, that's not plain view. Plain view is just lying right out there in front of you. So if it's in the plain view and the officer can see it with his eyes, that sense, sight, and he is lawfully on the premises, there's no reasonable expectation of privacy of what he can see. And so he doesn't need a search warrant to get it. The next time where it wouldn't apply is in open fields. And this is sort of like plain view. Items that are just laying out and open are not private. We're talking about like not inside your home. So things that are kind of lying out on the curb or in a lot next to a house or something. Items that are just kind of lying out in the open. Those types of things can be searched or seized, even if the officer's trespassing when he gets it. But it's just, there's no expectation of privacy because it's just laying out there. And then the last time it won't apply is with abandoned property. And really the only issue would be whether there was an intent to abandon it. So you toss something in the garbage, well, it's not private anymore because you just tossed it in a public garbage can. So the Fourth Amendment doesn't apply and the officer can just go pick it up. No warrant required there. All right, so those were the rules about searches and seizures of property. Now we're going to talk about people, searches and seizures of a person, including arrests. The Fourth Amendment, of course, applies here too. So the general rule, again, is that the officer must have a warrant to make an arrest, and that warrant must be based upon probable cause. And there are exceptions, as always. Officers don't have to get a warrant before arresting a person if they just witnessed them committing a crime. Or if another person comes running up to an officer and says, a felony is in progress. This man is around the corner robbing this lady. Okay, so the officer can run over there and seize the person. He doesn't have to stop and get a warrant. It's kind of like the exigent circumstances exception for searches, right? Doesn't that sound kind of like the same thing? So it really kind of is. In those situations, probable cause obviously exists because you got witnesses to what's happening right there. It's, the guy's doing it. He's caught red-handed. And there's just not time to stop and call a judge and get a warrant. So in those situations, you don't have to get a warrant to go arrest them. Certain other rules have been provided by case law about the manner in which an arrest can be made. Deadly force cannot be used unless it is necessary to protect life or to prevent the escape of a suspect for whom probable cause exists to believe that he or she poses an immediate threat of serious harm. So that's the rule. And that rule is the subject of a very important trial that is happening right now. And we'll see how that works out. And the next sort of precedent that has come out of the case law, officers who are going to a residence to make an arrest must knock and announce their presence before entering. That's known as the knock and announce rule. This rule just protects the privacy and sanctity of the home. But of course, there are exceptions, and that requirement is going to be relaxed when an escape is likely, or it's likely that evidence is going to be destroyed, or an officer may be injured if he's announced. All right, you got to pay attention to one thing. The Fourth Amendment uses the word seizure, not arrest. They say seizure. And the textbook makes the point that seizure could mean more than just a formal arrest where a suspect is handcuffed and taken to the station. There are other types of seizures too, and we're going to take a look at that. Obviously, a seizure includes an arrest, but it also includes detentions when a suspect is not handcuffed and taken to jail for booking. When an officer has reasonable suspicion that a crime has or is about to occur, he or she can stop a person, but no longer than necessary to alleviate the suspicion. If and only if stopping the person doesn't alleviate the officer's suspicion, then the officer may proceed to conduct a plain feel or frisk. That frisk is limited to just a pat down, just to ensure the officer's safety, not to search for evidence. We have a whole other set of rules for when you need a warrant to search for evidence. So this is not a search incident to arrest. We're not talking about that. This is known as an investigatory detention or a Terry stop. So it's named after the case Terry versus Ohio that first recognized the authority of the police to detain a person where an officer has a reasonable suspicion that criminal activity has or is occurring. So a seizure technically occurs then even when a person is driving. All right. We talked about this earlier a little bit with exceptions for search warrants, but now we're talking about it in connection with the authority to detain the person. So make sure you watch. There's two separate lines of analysis for searching and seizing the vehicle and stopping the person, the driver. Okay, so this is a separate sort of analysis. We're talking about the authority to detain the person who is driving or an occupant of the vehicle. So when a person is in a vehicle driving or is driving or an occupant of the vehicle, the officer can stop and detain the person and ask them to get out of the car. They can frisk the people for weapons, and this is just your pat down. And you can ask investigatory questions like, show me your driver's license. Do you have a weapon? That sort of thing. They can ask questions, frisk for weapons, make you get out of the car. And all they need is a reasonable suspicion that this person they have detained has or is committing a crime. And if you're wondering, what's the definition of reasonable suspicion versus probable cause? Well, it's also kind of like it's on a continuum as well. Probable cause is sort of weightier. Reasonable suspicion is like a little bit less. So it's where the officer has this hunch based upon their experience and their training, but they may not have enough for a warrant. So they can't get away with quite as much. But they can detain a person. They can do this sort of pat down frisk. But if they have probable cause, then they can actually arrest a person and do the other types of seizures. So this, again, is kind of on a little continuum. A lot of what we're learning is on a continuum. So that's the end of the Fourth Amendment. And as you can see, there are a lot of rules and exceptions. But notice as you're studying where those rules and exceptions fit in the continuum between the due process model and the crime control model. Ask yourself when you're studying, is the purpose of the rule or exception to protect the community, or is it to empower the police to act in the interest of safety? Or is the purpose of the rule or exception to protect individual rights of privacy or freedom? And that way you can kind of see where they fall in Herbert Packer's models. Okay, so now on to the Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So I've underlined the 5 due process rights that are found within the Fifth Amendment. And we've already talked about the requirement for a grand jury indictment. We learned that in connection with, I believe it was chapter 4, maybe, for federal trials. And we've also talked about due process, procedural and substantive due process generally. We're not going to study the takings clause at all. That's a little bit beyond the scope of this course. So what's left is the privilege against self-incrimination and double jeopardy. We're going to start with self-incrimination. The simple language is listed here. No person, ... shall be compelled in any criminal case to be a witness against himself. And the general rule, which we all know, is that defendants can refuse to testify. And they can't be coerced physically or mentally to testify, like no extended interrogations and isolation with sleep deprivation, all of that business. That's against the rule against, or the privilege against self-incrimination. So this rule now applies to states. Selective incorporation has been used for this right. But notice, this is a communicative or testimonial privilege. It does not apply to physical evidence. That's why officers can conduct sobriety tests. That's why they can take a suspect's fingerprints. That's why you have to give a blood sample when you're asked to do so as evidence of a crime. This privilege does not protect a defendant from giving up physical evidence, only testimonial, a communication of information from the defendant's memory or knowledge. I've cited the case there that stands for that rule, Pennsylvania versus Muniz. All right, double jeopardy. That's our next topic. It was discussed more in chapter 5 than it is here, or the textbook talks about it in chapter 5, but I think it fits better with the discussion of criminal process. So I've waited until chapter 6 to go over it. Double jeopardy restrains the same government from continually prosecuting the same person for the same offense. So notice I said the same government. When a crime crosses state borders, both states can prosecute and punish the defendant. When the two states are separate sovereigns, so they both have the authority to prosecute and punish crimes within their jurisdiction, and they don't lose that authority just because another state beats them to it. And the federal government can pursue a defendant that has already been prosecuted by the state for the same offense. Also, double jeopardy only applies to the same offense. A defendant can't be prosecuted twice for the same murder, but if the same set of facts provides evidence of a different offense, the defendant, having been acquitted for murder perhaps, could still be prosecuted for a different offense arising from the same factual situation. Oh, and last, double jeopardy doesn't attach to mistrials or hung juries. It only attaches to acquittals or convictions. When a conviction is overturned on appeal, the state can retry the defendant. So we moved through that one fast. Now we're going to do the Sixth Amendment. And it also includes a lot of due process guarantees. The right to a speedy and public trial, the right to an impartial jury, and the right to be informed of the charges against a person. Those were all topics that we talked about in, it was either, I think it was chapter 4 when we were talking about the stages of a criminal trial. We talked about those topics there, and we're not going to go through them again. What we're going to talk about here now is confrontation, subpoena power, and the assistance of counsel. Both the right to confront adverse witnesses and the right to subpoena witnesses are guarantees that allow the defendant to defend himself or herself. These are basic rights that are easy to grasp. Defendants have the right to cross-examine the prosecution's witnesses, to test their credibility, and to eliminate hearsay statements. And as is often the case, there are exceptions for that right to cross-examine. The book mentions a couple of them, but we don't need to go into quite so much detail. And then there's also the right of the defendant to compel witnesses to testify on his behalf or her behalf when their testimony is relevant, not cumulative to what's already been presented. So they can cross-examine and they can subpoena and make people testify for them. All right, next, the right to the assistance of counsel. The language of the Sixth Amendment says this: you have the right to have the assistance of counsel for his defense. Okay, it means now, but originally, all that meant was that the defendant had a right to have an attorney, meaning they can hire an attorney to defend him and her. All right, but over time, several Supreme Court decisions elaborated upon that right in order to overcome historical, often racist abuses of power by state and local governments. And one of those situations happened in the case of the Scottsboro Boys. You should have watched a video in connection with Chapter 2 about the Scottsboro Boys case, and their attorneys were not effective at providing a defense. One was drunk and the other one had no experience with criminal defense work at all. So in the case of Powell versus Alabama, the court held that this right required the appointment at government expense of defense attorneys for indigent, okay, so poor is another way of saying that. Just you can't afford to have, if you can't afford to hire an attorney, the government has to provide one for you if you were facing the death penalty. And then later decisions expanded on that right even further and ultimately gave us this current general rule. So this is the current rule that you need to learn. In all states and federal courts, state and federal, okay, so this has been incorporated through the 14th Amendment to apply to states. In all state and federal courts, any indigent defendant facing incarceration for a felony or misdemeanor with a possible sentence of 6 months or more must be represented by counsel. All right, that rule or that right arises at any critical stage. And I've got that in quotation marks because it is a specific concept with its own little analysis. A critical stage in the prosecution. That's when the right arises, at any critical stage in the prosecution. That includes most pre-trial events, okay? So what is a critical stage in a prosecution? Well, that's determined on a case-by-case basis. But basically, it just means once an investigation is focused on a specific defendant, when it's no longer just a general investigation, the cops are questioning witnesses and trying to gather up evidence. No, it's when they narrow their focus down to one specific person. Thereafter, we've got a critical stage in the prosecution and the right to counsel arises. You know, it really it works out because they'll arrest somebody once they've kind of narrowed their focus. They're going to arrest whoever their focus is and Mirandize them and say, you've got the right to counsel. Okay. So you see how it kind of all works out. There will be debate. There'll be some cases about, well, you were questioning a witness and something that they said caused you to focus on them. And so, you know, when does the interrogation stop? When do they need to stop asking questions and say, oh, okay, you probably need to get an attorney now. So there's a judgment call. It kind of gets a little fuzzy there. But the main point for you to know is just that the right to counsel arises at any critical stage in the prosecution. All right, we got 2 more topics to go. And these last 2 topics that we'll cover they are not due process rights that are found directly in the Constitution. So we're done going through the rights in the 4th, 5th, and 6th Amendment. Our last two topics are rules that developed from Supreme Court cases, and they're about enforcing the rights that we just identified in the 4th, 5th, and 6th Amendments. So the next two topics are about enforcement of those rights that we previously identified. They are Miranda and the exclusionary rule. We're going to start with the exclusionary rule. The exclusionary rule prevents the prosecution from using evidence that was illegally obtained in order to directly establish the defendant's guilt. So if the prosecution obtains evidence from a search that was conducted without a warrant, or from an interrogation conducted outside the presence of counsel, for example, then the prosecution cannot use that evidence or testimony to directly establish the defendant's guilt. And it also applies through what is called the fruit of the poisonous tree. Any evidence derived from illegally obtained evidence is likewise excluded by this rule. Now, the whole purpose of the exclusionary rule is to deter police misconduct and protect the integrity of the judicial system. Due process rights wouldn't mean anything if the government had the power to use the evidence obtained in violation of them against the individual. There has to be some way to police the police, essentially. We have to be able to hold the prosecution accountable for their conduct in violation of due process rights. And that's why illegally obtained evidence cannot be used. Now, there is some debate still surrounding the justness of the exclusionary rule. And you can see how it might be problematic in the case of Brewer versus Williams, where the young girl was abducted from the YMCA. It was plainly clear that Williams was a child murderer. He was factually guilty. Everybody knew it. But the evidence establishing his legal guilt could not be used to convict him because it was illegally obtained. Now, this is the due process model of the justice system at play. A factually guilty man was going to go free on what some might call a technicality. But we certainly don't want police to get away with due process violations completely. There are maybe other ways to hold them accountable. For example, we might create a civil remedy for due process violations or an administrative agency to punish violations. With those alternatives, the police would be policed, but just not through excluding the evidence. So far, however, the Supreme Court has not approved of any of these alternative methods. There is a little history to the exclusionary rule that you ought to know. This rule first emerged in 1914 in the decision of Weeks versus United States. In that case, the Supreme Court first applied the exclusionary rule in federal prosecutions. So in 1914, this is before the court had begun incorporating the Bill of Rights into the 14th Amendment in order to hold state governments accountable. So in the Weeks case, there was left this large loophole, okay? It was known as the Silver Platter Doctrine. State prosecutors could still present this illegally obtained evidence at trial because it was illegally obtained by federal officers, and the rule didn't apply to states yet. So, the federal government can't use it, or the federal prosecutor can't use it because it was taken in violation of due process rights. But a state with jurisdiction can prosecute the defendant for the exact same offense and use this illegally obtained evidence. Also, states could share their illegally obtained evidence with the federal law enforcement officers, and federal prosecutors would be able to use it at trial because they weren't the ones who illegally obtained it. So you've got this little loophole here. About 35 years later, in the case of Wolf versus Colorado, well, there the Supreme Court incorporated the Fourth Amendment into the 14th so that state governments were bound by its protection for individual rights pertaining to search and seizure. And in the Wolf case, the court considered whether to enforce the Fourth Amendment with the exclusionary rule. But at least in that case, they chose not to. And the exclusionary rule remained just a remedy against a federal officer's abuse. So in the Wolf case, the Supreme Court incorporated the rights, but not the mechanism for their enforcement. They were going to leave it up to the state to decide how best to enforce the rights that are guaranteed by the Fourth Amendment. The how of it, essentially. But about 30 more years passed, and in the case of Mapp versus Ohio, the Supreme Court finally held that the exclusionary rule applied to states. And in that case, there was a discussion about these alternative methods for enforcing the due process rules other than the exclusionary rule, but at least the ones that were before the court then were found to be ineffectual, so they weren't adopted. Anyway, you can see through the exclusionary rule how the law has progressed and changed over about the past 50 years. The law really adapts a lot to changes in our society. All right, so you're not going to be surprised to learn that there are several exceptions to the exclusionary rule. And I put them here on the slide in the two little blocks that reflect Packer's models of the justice system: due process on one, crime control on the other side. Remember, this is a continuum, people. It's not all or nothing here. So if you put the exclusionary rule neatly into the due process camp, then the exceptions will fit very neatly in the crime control camp. So here are the exceptions. Illegally obtained evidence can be used for the purpose of impeaching a criminal defendant's testimony. So impeaching just means showing them to be a liar, showing that they are not credible. So you can't use it for the purpose of establishing guilt, like the ultimate guilt of the defendant. But if he testifies, you can use it to challenge his credibility, to show him to be a liar. Second, illegally obtained evidence can be used to obtain grand jury indictments. Third, illegally obtained evidence can be used in civil trials or in probation and parole hearings. Fourth, standing is also an issue. Only the individual who had an expectation of privacy over the property searched or seized may actually assert the exclusionary rule as a remedy. Fifth, if the illegally obtained evidence could be obtained from an independent source, then it can be used against the defendant. Sixth, if the police misconduct is attenuated from the collection of the evidence, then the evidence can be used. This is sort of like the absence of legal causation. We talked about causation in Chapter 5 with crimes. So here's where it kind of falls in with criminal process. If the police misconduct didn't lead fairly directly to the discovery of the evidence, then the evidence can still be used. This is just a way of saying that old fruit of the poisonous tree doctrine, you can't stretch it too far. There is a limit. Seventh, if police officers acted properly, but the judge or clerk or some other state actor messed up, then the evidence the police obtained from a bad warrant can still be used because the police officers weren't the ones who were getting it wrong. It was someone else kind of separate from them. And last, as we saw in the sort of the sequel to the Brewer versus Williams case, if evidence is inevitably would have been discovered by the police regardless of their misconduct, then the evidence may be used. So this is what happened when Williams was retried for Pamela's murder. They were able to show that they would have found her body and the other evidence that led to his conviction anyway, even in spite of his interrogation. So They were able to get the evidence before the jury that way, and he was convicted and imprisoned. In the end, he did not walk free. He died in prison. So you can see real easily in this slide that pendulum swing back and forth. The rule comes out, well, really, you start with the due process amendments, and then you have this rule enforcing it. And the pendulum's kind of over there in the due process side. But then over time, it kind of swings back over to the crime control side with all these exceptions to the exclusionary rule. All right, last we're going to talk about Miranda, the Miranda rule. And I'm pretty certain everybody has heard of the Miranda warnings. I bet you could just recite that just from watching crime dramas. But you've got to hear the whole, the legal version of it, right? Not the Netflix version of it. The Supreme Court decision, Miranda versus Arizona from 1966, requires law enforcement officers to inform an individual of both the privilege against self-incrimination and the right to counsel before a custodial interrogation may begin. Otherwise, the exclusionary rule will kick in and the evidence obtained during the interrogation will not be admissible. So this is pretty simple and a pretty well-known rule, but it is important to consider what is meant by the phrase custodial interrogation. Custodial or custody means a formal arrest or its equivalent restraint, when a reasonable person would conclude that he or she is not free to leave based upon the actions of the police, the location of the encounter, or the time of the encounter. And interrogation, the police activity that is reasonably likely to evoke an incriminating response. So not only your standard question and answer, but also its equivalent. So if you remember, again, the Brewer case, the officer Leeming gave the Christian burial speech to Williams in the car as he was driving to Des Moines. So he was clearly in the custody of the police. They're driving him from one city to another. And he isn't asked questions, but he is technically interrogated because Leeming said he wanted to evoke an incriminating response from Williams by giving that speech. So in effect, it was an interrogation conducted while Williams was in police custody. Therefore, it was a custodial interrogation, and his right to counsel should have been protected. When a person is not in custodial interrogation, Miranda warnings are not required. And this is like sobriety checkpoints or statements that are just sort of volunteered without any prompting by the officer. So those are not custodial interrogations, and Miranda is not required. But once a person invokes the right to remain silent, like they say, no comment, or I want my attorney, okay, all questioning must stop, even if it pertains to a different offense. Also, as we saw in Brewer versus Williams, the right to remain silent can be waived by a person in custody. And as we saw, though, waiver may be really difficult to prove, right? So it didn't work in the Williams case. They could not prove waiver. The prosecution has to show that waiver is knowing, intelligent, and voluntary. Another important point, if a defendant is not Mirandized, or if the defendant responds to interrogation after invoking the right, the defendant's statements can still be used for a limited purpose, and that is to impeach the defendant. Remember, that was one of the exceptions to the exclusionary rule. So they can still use these statements made, even though they weren't Mirandized. You could still use them to show that the defendant is lying. Like they take the stand and they start to testify and they say things different from what they said to the police. Well, may not be able to establish their guilt, but you can show what they said previously to make them out, or to make the jury see that they're lying, or they were lying then or they're lying now, one or the other. So the Miranda rule then only prevents the prosecution from using illegally obtained statements as direct evidence of guilt. they can still be used to show the jury that he's a liar. All right, so that's the end of the lecture for chapter 6. I want you to go now and take the quiz for chapter 6. And of course, email me if anything I said didn't make complete sense.